Good evening, everyone, and welcome to another edition of my weekly series entitled Legal Ease, where I discuss legal issues and I answer your questions and try to give you good advice concerning legal situations that you or a loved one may find yourself in. Now, I am a personal injury attorney, but I'm also a criminal defense attorney, so I'm able to give advice and direction and talk about those subjects pretty cogently. But I also like to get into other issues that some people present to me in terms of questions. But this week is going to be an interesting one. I attempted it actually last week, but we had a technical difficulty. So I'm going to reshoot this for you this week. And if you like what you hear today, please smash the like button. Feel free to share or comment below. And we're going to talk about DUI in the state of Florida and what it can cost you. Now, I'm not just talking about what it can cost in terms of money, although that's going to be the main thrust. But we're going to talk about it in terms of what it can cost somebody's health, their lives, and also how it's going to affect your pocketbook. And we're going to talk about that mostly at the end. So, Florida has one of the toughest DUI law regimen in the entire country. The DUI statutes in Florida are particularly strict. And in Florida, you really, really want to avoid getting charged with a DUI if you can. Now, nowadays, there are so many ways that you can avoid it. I mean, we have, with COVID, hopefully you're not going out and partying too much anyway at bars and things like that, but people still are, and the bars are still open, at least in this state. But you have ways to avoid the DUI, which is always the first thing you should try to do. And very easily, call Uber or call Lyft. You can pay a small amount of money to save you a ton of money and trouble and heartache later on. And I highly recommend you do that. Even if you're not sure, even if you just had one drink, what could it hurt? Hire the Uber, hire the taxi cab, call a friend, call a family member, but really avoid putting yourself in the situation where you're drinking and driving, particularly with the holidays coming up. It's one of the reasons why I wanted to present this now, because with Thanksgiving and with Christmas and New Year's coming up, people are going to be drinking and people are going to be driving. And drinking and driving is not a crime unless certain issues apply. And let me explain what those are, certain circumstances. You can drink and you can drive in the state of Florida, but if you are discovered drinking and driving and you're under the influence to the extent your normal faculties are impaired, and your normal faculties, your ability to walk and talk and make judgment calls and respond to emergencies and kind of do all those things that we're required to do in our lives normally, then your normal faculties are impaired. Now, in the state of Florida, all that needs to be proven is not that you're a drunken slob. Some people think, oh, I wasn't that drunk. I wasn't that drunk. This is all very elemental. When the state has you in a trial and they're trying to make their case to the jury, they just have to prove a few things. First, they have to prove that you're driving or that you were in actual physical control of your vehicle. And that's one of those scenarios, actual physical control, where you're in the car, but the car's not running, but the keys are in the car. And that is a discussion for a different day. I'll get into more detail about that in the next few weeks, about what specifically equals actual physical control. But driving or an actual physical control of the vehicle. The second element is that you're under the influence of alcohol or a controlled substance. And if you are partying and drinking and possibly using recreational substances, including legal ones like marijuana, then as far as in the medical context, and you could potentially be charged with DUI if you're under its influence to the extent your normal faculties are impaired. That's the third element. The normal faculties have to be impaired. Now, there is the blood alcohol test that's done. And if your blood alcohol equals 0.180 or 0.08, I should say, milligrams per deciliter, then you are considered to be in a position where if a jury wanted to take it at face value, you are then presumed, a juror can presume at that blood alcohol level that you are in a state where your normal faculties are impaired. So if the state can prove that you have a 0.08 or higher milligrams per deciliter breath alcohol, then a juror may presume. They don't have to, and the presumption can be rebutted by other evidence, but that's a pretty strong presumption for people that are uneducated and learning the law and the facts of your case the day they step into the courtroom. So basically, if you were to have a blood alcohol level of, say, 0.10, which is 0.02 of a point above the legal limit, that would mean that 1% of your bloodstream is composed of alcohol. You've had enough alcohol that 1% of your blood is now considered to be that toxic, 1%. Now, Florida, as in most states, 0.008 is the legal limit. However, even if your blood alcohol is below the legal limit, if the state can demonstrate that your normal faculties are impaired, you can still be convicted of the DUI. And that's really the problem. And you know, once you're in that situation, you're kind of going to wish you weren't. So do the thing that's intelligent and get yourself a ride home. You really won't regret it. And you know, as I indicated, the penalties for DUI are pretty strong in the state of Florida. Now, for a first-time offense, and this is just you're charged with DUI, you've either blown under a 0.15, or you have refused to blow, and there are no crashes involved and no minors in the vehicle, you could still be potentially sentenced to 6 months in jail in the event you're convicted if you go to trial. Now, there's no minimum jail time that's required on a first-time DUI with no aggravators in the state of Florida. However, a judge has the discretion, and the state may ask for up to 6 months in jail, and a judge could grant that if he were so inclined. Now, if your blood alcohol level is 0.15 or higher, or you're driving perhaps with a minor in the vehicle, then you could be looking at 9 months in jail if convicted after a trial, and up to 12 months if there is a crash involved. So these are potential penalties, and this is really just the tip of the iceberg. This is confinement, and interestingly, people seem less concerned about confinement sometimes as opposed to what it'll cost them out of pocket. Now, and that's just a first-time DUI. If you're charged with a second DUI, and if this DUI is charged within 5 years of your conviction from the first, so you have your first DUI, and if before 5 years passes from the date of your conviction, you're charged with another DUI, and you're convicted of that DUI, then you must serve a mandatory minimum of 10 days in the county jail. Of course, the court, under certain circumstances, has discretion to commute the 10 days jail sentence and allow you to substitute a residential rehabilitation program instead of jail time. Well, shout out to the people that are watching me this evening. Hey, everybody. I see that Lisa DeBarry is there. Hello. Vanessa Gonzalez as well. Thank you for tuning in. I hope that you're getting some good stuff out of this. So I just talked about the second within 5. Now, if your arrest is outside of 5 years, your second arrest is outside of the date of conviction of your first DUI, and you refused blood or breath registered below a 0.15, and there's no crash, you can face a maximum of 9 months in jail if convicted after a trial. But there's no minimum jail time. So on a second outside of 5, there's no requirement that you be put in jail. However, if you risk it, go to trial, and lose, then the court has the discretion, and the state can ask for up to 9 months. If your DUI arrest is more than 5 years, for the third offense of DUI, and if your arrest is within 10 years of your 2 other DUI convictions, so first DUI conviction, second DUI conviction, if that third one is within 10 years of the second DUI conviction, then you're charged with what's called third within 10. That's kind of like second within 5, only worse because it's third within 10. And there is a 30-day minimum jail time on a conviction for a DUI third within 10 without aggravators. So you can imagine if the blood alcohol is over 0.15, or people are injured, or if there are minors in the vehicle, then the sanctions are even worse. If your third DUI is more than 10 years after your 2 other convictions, there's no minimum jail time for the third outside of 10, but for the third inside of 10, there's a minimum of 30 days in jail and a maximum potentially of 12 months in county jail if you're convicted after a trial, if the judge at his discretion wants to sentence you that way, and it does happen. If your third DUI, however, occurs outside of 10 years from the first 2 convictions, then there is no requirement that you serve a minimum jail time, and probably would just be based upon the factors of the case that the state would request however much, and they may just anyway, because it's a third, request jail time, because it sometimes uses a leverage against a defendant that may want to resist pleading. So they try to strong arm you. And if you were charged a fourth time on DUI, it's going to be a felony. They're just going to charge you with felony. You're going to be sentenced to confinement, potentially up to 5 years if you're convicted after a trial. So a felony, a third-degree felony, without aggravators, without manslaughter, without leaving the scene of an accident with a fatality, just a straight fourth DUI can be charged as a felony, and you could be sent to prison. So now that's just the jail time. Then there is the loss of driving privilege, and driver's license suspensions are handed down immediately following an arrest, and we have to get involved in the administrative process to get you the hardship license, which is available on the first and second DUIs in the beginning. Then when you get a third, you have to wait after your case is done and after a period of time before you can get your regular license. So a first-time DUI, you're looking at 6 months suspension with a maximum of 1 year based upon the circumstances. Now, for a second offense, if it's within 5 years of your first, then the suspension will be for a 5-year period of time with the possibility of a hardship license after you serve the first year of suspension of the 5. So you get convicted of a second within 5 DUI, you then wait 1 year, and then you can apply for a hardship license, which allows you to drive, but for limited purposes, to the grocery store, to the doctor, maybe to take your kids to school, but you're not for pleasure, and not to the beach, not to the movies. Not that any of us are going to the movies anytime soon, but a lot of people are still going to the beach. For a third offense, it's a minimum 10-year suspension with eligibility for hardship after 2 years, and you go to the Bureau of Administrative Review's arm of the DMV, and you would then apply for the hardship license, which could be granted, but then you're going to be in a state of limited driving under that. And then for a fourth offense, there is a permanent revocation of your license with no eligibility for a hardship or reinstatement. That doesn't matter if the fourth DUI came within any amount of time of the other three. It's just you're going to lose the license permanently. And so now you know what the potential incarceration implications as well as the suspension of the driving privilege. And these two enough should be really sufficient for anybody with common sense to be careful. And the thing about DUI is this. I've said this before. Not everybody beats their spouse. Not everybody abuses illegal substances. Not everybody attempts to murder somebody, thank God. But a lot of people drink, and a lot of people drink and drive. It's probably the one offense in all of the criminal realm that seems to potentially befall the most different kinds of people. So it can happen to anybody. All you need to do is be behind the wheel of the car, either driving or in actual physical control of the vehicle, in the back seat of the car when the keys are in the car, if the car's not even running, and you could potentially be stopped. And if you're under the influence and they can prove that your normal faculties are impaired, then you're going to be in that situation where you're facing those sanctions. So in addition to the incarcerative and the administrative and the criminal suspensions of your license, you're also going to pay some fines. So on a first offense for DUI, you're going to be looking at $500 to $1,000, and that's without aggravators. Now, if there's a minor in the vehicle and the blood alcohol level is 0.15 milligrams per deciliter or higher, then the fines increase to $1,000 to $2,000 on a first offense. On a second offense, without aggravators, you're looking at $1,000 to $2,000. And if there's a minor in the vehicle or the blood alcohol level is over 0.1 or 0.15 or higher, then the fines can increase anywhere from $2,000 to $4,000. So this is becoming a very expensive proposition. And for a third offense, without aggravators, you're looking at $2,000 to $5,000 in court costs. And if there's a minor in the vehicle or the blood alcohol levels of 0.15 or higher, the fines could be anywhere from $4,000 to $5,000. And on a fourth offense, even without aggravating factors, you're not going to pay any less than $2,000, probably pay more. And those are just the court costs. That is just what you owe the court if you're convicted of the DUI or if you enter a plea, either after you enter a plea or you go to trial and you lose. You will end up paying those fines, and that hurts. So those are just the straight fines. But then there are the other things that you need to be responsible for. So if you ever have any hope of getting a real driver's license back again, then you're going to need to, under certain circumstances, incur some additional expenses. So in a first-time DUI, you've never had one before, you've never charged DUI before, suppose your blood alcohol level is a 0.15 or higher, and you will be required to carry an ignition interlock device. Now, in a first-time DUI, where the blood alcohol level is below 0.15, or even if you refuse to blow, then you're not required to have the ignition interlock device. But if the blood alcohol level is 0.15 milligrams per deciliter or higher, then they're going to require, the state is going to require, and the DMV is going to require that you have the ignition interlock device installed on your car for at least 6 months before you have the possibility of getting your regular driver's license reinstated. And that's very, very important because you have to pay for this on a monthly basis, usually somewhere to the tune of about $90 a month. And for 6 months, that's $540 extra money on top of everything else. So for a second offense, the interlock would be required for a minimum of 1 year for a blow that's below a 0.15, and for a maximum of 2 years if the blood alcohol is 0.15 milligrams per deciliter or higher. So there's an aggravation factor there that they consider, and you can have it for 2 years, and just do the math times 4. You're looking at 2,000 and change. And for a third offense, it would be a minimum of using the interlock ignition system for 2 years. Doesn't matter what the aggravators are in that case, you're going to have it for at least 2 years, maybe more. And for a fourth offense, 2 years of using an ignition interlock system, I didn't think it will apply because you're losing your license at that point in time. Now, you also have your community service requirements on the first-time DUI. You have 50 hours of community service, and if you're somebody that doesn't have the ability or the time to work these hours, then you can buy out community service hours if the court allows you to, for $10 an hour typically. Of course, there are going to be 3 hours that you can't buy out, that you have to attend the victim impact panel, which you can't buy out. So that's going to be 3 hours of your time at least. But if you buy out your community service hours, you're looking at another $470. They're also going to immobilize your vehicle. For the first conviction, they're going to do it for 10 days. For a second DUI, within 5, they're going to immobilize your vehicle for 30 days. For a third, within 10, 90, and for a fourth, 90 days. And the requirement that your vehicle be immobilized, and usually what they'll do is they'll come and put a sticker or a boot on the car, and that way you can't operate the vehicle. However, you can successfully argue, if you argue successfully to the court, your lawyer can present information to the court that it would be a hardship on a third party to immobilize your vehicle for so long, then the court can commute that requirement. If it's the only car and 3 people in the family, or even 2 people in the family need to use it, then the judge might be lenient with that and commute that requirement. Hey, Barbara is here. Barbara Nicelonger, how you doing, Barbara? Nice to see you. Thank you for tuning in. Great to see everybody. And of course, on top of the suspensions, on top of the jail, on top of the financial requirements, and you have the ignition interlock device requirement, then you also have the DUI school and the education programs that are required. So you're going to be required to attend classroom sessions for a first-time level 1 DUI. You're going to pay about $500 additionally, and you're going to sign up for it. You've got to go and spend an entire weekend of your life doing that. Then they're going to evaluate you, and they're going to determine, based upon that evaluation, whether or not you require up to 16 weeks of treatment, which is costly as well. So that's another thing to consider. Basically, if you do not do these things, and they're all going to be conditions of probation, the DUI school, the suspensions, the ignition interlock devices, they are going to be enforced. So if you do not complete them successfully, then you will not be able to reinstate your license and properly drive in the state of Florida. So just to give you the cost breakdown of this now, again, at the court, now I'm going to give you the minimum breakdown, like the least offensive situation and what it'll cost you. Court costs are going to be a minimum of $500, and there's just no escaping it. With aggravated, $1,000 even on a first-time DUI. Probation is another thing, and you're going to have to pay $55 per month of supervision. And let's suppose that you are on probation for 12 months. That's going to be $660. Or if you get early termination, say after 6 months, $330. DUI school is going to run you about $500. The ignition interlock device is going to run you about $540. at $90 a month for a period of 6 months. And if you blow a .15 or higher, that's going to be required on a first time, and it will be required on a second DUI, whether or not you blew a .15 or refused either. And then this is a really interesting one. This is the one that really, really gets people that they don't really think about. There's Sr22 Insurance. And Sr22 insurance is particularly expensive. I mean, it is a special kind of insurance that people have to carry if they have been charged with a DUI, if they want to get their license reinstated. So typically what happened would be, if you're convicted for driving under the influence, and say it's a first-time offense, your conviction suspension kicks in. So say you had a refusal and you're going to be suspended for, suppose you have 6 months, well, it's not regular DUI, so 6 month suspension. After that 6 month passes, you can then apply for your regular driver's license. However, you're going to have to carry Sr22 insurance. You're going to have to call the insurance companies that'll write this. Progressive is one of the ones that write this. Some of the other carriers write them. And essentially, you're looking at $500 or so a month to insure the vehicle under Sr22 insurance. That's pretty standard. And for a 6 month period of time, that $500 is going to be a premium of $3,000. So do the math. If you're required to carry that insurance, I mean, you are going to pay out the wazoo for that. That's just a lot of money, but it's required, and you can't get a regular license reinstated until you've satisfied the Sr22 insurance requirements. So under even a minimum of circumstances, I'm going to put the price tag of your DUI at anywhere from I'd say $25,000 to $30,000. Because you have to hire an attorney too, and attorneys, we don't work for free. We try to do a great bang up job for our clients, and but that takes money. And you can go with a public defender if you want to, but they're very, very busy people, and they don't have the time to dedicate toward your case that a private attorney is going to have. But at the end of the day, the private attorney is going to charge you. And for a DUI, you can look anywhere from, I've seen anywhere from $1,500 to $5,000 to hire an attorney for a first-time DUI. So you're looking at close to a $30,000 price tag for that offense alone. And that's just the money. A lot of people are excited if they can get out of a situation with just having to owe money. What's less exciting and what's worse, and obviously tragic, is when somebody's driving under the influence and they have hurt somebody else or taken someone else's life. It could be the person in the other vehicle. It could be one of their passengers. It could be a pedestrian, somebody on a bicycle. It could be a family member of their own riding in their car if there's an accident that's caused by a person's intoxication. And you cannot pay any amount of money to undo the damage that's done in those situations. And that is one of the reasons why you have to avoid this at all costs. Now, one of the things that I get hired for is defending people for charges of driving under the influence of alcohol. But in my bodily injury practice, where I see the damage that's done to the clients for driving under the influence and the harm and the hardship to the families, it is not worth it. It is not worth it. Terry Yannick asked a question: can a DUI affect a person's auto insurance premiums even if they're not required to carry Sr22? Well, once the period of Sr22 insurance is met, then you are going to have a DUI in your record every time you apply for auto insurance. So that's going to be a factor that's going to be, on your record, for years. I mean, some people say it'll fall off after 7 years, but no, they're going to know about that. And underwriting is going to have a difficult time with you, or you're going to have a difficult time with underwriting if you have a conviction for DUI on your records. Even if you have an arrest for DUI that was perhaps reduced to reckless driving, you have to disclose this information in your applications, and you can't lie to the insurance companies, because that in and of itself is a felony. So yes, having had Sr22 and then we try to apply for regular insurance, of course the insurance companies are going to consider that. The Sr22 is the requirement that you need to fulfill in order to be able to have a normal license again, a regular driver's license. However, the insurance carriers are going to be aware of this, and they are going to rate you accordingly and one can certainly understand why. But once again, back to what I was talking about as far as the damage to life and limb and the loss of life, and particularly now around the holidays, and it's been a difficult year. It really, really has. The COVID thing has really, really done a number on a lot of people. There's a lot of depression and a lot of reasons why people may want to drink and want to party, and that's all normal. But what isn't normal is getting behind the wheel when you are intoxicated to the point where you should not be driving. And in that particular situation, get on the Uber app, get on the Lyft app, call a family member, or walk. It'll be worth your time. You can prevent a horrible thing from happening to you or other people. Even at a minimum, a DUI is a horrible burden and inconvenience on a person's life, not to mention if somebody is injured or killed as a result of somebody's intoxication. So not to get too preachy, but those are the facts. And I've been doing this for 20 years and I've seen quite a bit of it. And, the result of making the unwise decision is never a good one. But anyway, thank you for tuning in tonight, folks. Thank you for your time and thank you for your questions. And if you liked what you heard, please smash the like button. Feel free to share this information. Feel free to comment below. I do segments based upon people's questions, and I certainly appreciate your contribution and your input and your criticism too. So if you have something critical that you like to level my way, then I'm more than happy to respond to that. Hey, well, Margie Schumacher. Hey, Margie, thank you for popping. Margie Peebler, I'm sorry. You used to be Margie Schumacher. But anyway, folks, thank you very much for tuning in this evening. It really means a lot. And I hope you have a very safe and happy Thanksgiving. We'll see you in a week.